Chitab kolenjin itagat missing en ngunon ko atkai tugul tetutiet nebo Ikweny Emet kikonyi tuguk cheterter chetesetai en emet nebo Kenya kobun oret noton nebo ng'alalutik chetindoi ak toek chebwone studio noton bo Kass TV. Kainenyun ko Victor Korir ako en ngunon ketindoi tondet netai nekitindoi en betutab rani. Inendet ko ogiliot noton naat ko constitutional lawyer. Inendet ko naat ko Daktari Pharez. Yeah, that's the correct pronunciation. Yeah?
Yes.
Yeah, karibu sana kwenye studio ya Kass TV. Ni mara yako ya kwanza kuja hapa. Na today we just want to try to understand the role or the current state of affairs in our judiciary. The state of relations between the judiciary and the executive. In your opinion, as a member of the profession, what would you say, how would you describe the current climate?
First, I'm grateful to be here. And I think the question of the separation of powers has been well articulated over the years. The Constitution of Kenya is very clear. We have the Supremacy Clause, which gives the supremacy of the Constitution. We know the judiciary, the executive are the arms of government that are well outlined within the Constitution of Kenya 2010. We understand what is perceived as a current stalemate or perceived. I would call it perceived. I would not call it a stalemate in the strict sense of it. We have the judicial functions which are well outlined, which of course the executive knows very well. So what we are looking at right now is weighing out what would call the perceived stalemate vis-a-vis what is really what we would call in practice the doctrine of the separation of powers, which we have the doctrine in the strict sense of it, which is documented, and then there is the implementation phase where we meet certain directives that can be given by the court, in essence, because in exercise of its powers that is vested, then we find the executive countering such directives that have been issued by the court. But in essence, we still don't think we have reached to the place where we can say the executive is undermining the judiciary in the strict sense. We understand the functions of the executive through the presidency, and the actions are well laid out because all are state functions. They are bound by the Constitution, the presidency, supremacy, the supremacy of the Constitution under Article 2 gives all state all state officials to be bound by the Constitution, including the judiciary itself. So in any given time, should there arise an impasse between the two, of course the Constitution will reign supreme as far as the matters of national importance, because here we are looking at the presidency that is determined to give to the people according to the outlined agendas during the forums that the presidency would articulate and say, we would like to provide, for instance, affordable housing, we provide healthcare, we would like to provide certain services that we deem will elevate the livelihood, will make things different. So in that quest, then comes now the impasse between what we call ideal versus the question of what is outlined in the Constitution. There is, of course, the prerogative of the presidency through to improve through the agenda that has set out for the people of Kenya, for instance. So some of this now comes up through, because we feel really strongly, because we have the Office of the Attorney General, which is the principal legal advisor, which of course we think at this point, should anything emerge, a policy or any of these service delivery through the Office of the Presidency, if it is measured against certain safeguards of the Constitution, for instance, it is the prerogative to advise how well, to advise the presidency how well to bring out this service delivery, because the power is vested in the people, because the supremacy gives all power is to the people. So when, for instance, the implementation phase is met with certain aspects or thresholds that are not deemed as satisfactory in that case, then it brings about the impasse because we don't find it, we don't find the real deal, the real issues that are pressing to improve the economy, to change livelihoods, to make things a bit different. I don't think that is the object that is being opposed in the real sense. I think the implementation force or how it is coming into place is something that should be articulated and is something that requires public participation. It requires the voice of the people. It requires to be measured against thresholds and what would make it comfortable for the people.
You've mentioned two things.
Yes.
You've mentioned public participation.
Yes.
And you've mentioned the office of the Attorney General.
Yes.
Now, some of these, let's say, policies that the government has been trying to pass, as well-intentioned as they may be, they have faced some obstacles in the courts of law. And some of the issues that have come up during these proceedings is the matter of public participation. And the question that arises is, does the AG take time to go through these policies before they come out of cabinet to go to parliament? I mean, he's there, he is a member of the cabinet. And he should be there telling people, you know, let's not go down this route before we satisfy this and such a, you know, a requirement by the Constitution. Then when the case comes to court, I mean, judges will always abide by the rule of law. Then at one time or another, they may shoot down a policy, you know, that the government is trying to implement. And then the government now comes back, lashes out, says that the judiciary is undermining the agenda, is not, you know, really considering the wishes of the people. What role does the AG have to do in advising the government to avoid some of these embarrassments?
Well, like I said, the Office of the Attorney General, the principal advisor to the government, we know they are well equipped as far as understanding policies, strategy, the legal implementation, there's a framework, everything else is outlined. For instance, issues on taxes, issues on affordable housing, issues of medical, the whole overhaul of the medical what do you call this? Yes, the medical insurance cover. So there are many other avenues how they come in to advise the executive through the Office of the Presidency. Because in service delivery, it has to be outlined in a way that it's not oppressive, but at the same time, it gives effect to the main agenda, which is, of course, to provide affordable medical services that is top-notch level, improve, for instance, infrastructure, improve all these. They're all, I mean, there are different facets of the law that touches on every specific service delivery. You see, it is not a one-stop shop. You cannot say, because when you touch, for instance, the medical field, of course, you know, there are certain safeguards that are outlined there, and then still it falls back to the Constitution because it falls back to the people. So it should be thrown back to the people to weigh against what is the policy really trying to achieve. If we look at the medical field, for instance, you're looking at the medical insurance, we are weighing it against the question of affordability. We are looking at the rate of employment, how many people can afford it. I mean, if we scale it to a level that it becomes a painstaking affair for the common person, then you find now the matter falls back to the court. Then are we able, because the courts, of course, are vested. It's a constitutional safeguard, you know. The Constitution provides that if anybody is aggrieved by any decision, then they can go to the court. We have the hierarchy of the courts, starting from the lower courts all the way to the apex courts. And of course, if the judicial functions are left without any interferences from the executive, because if the executive is passing the sound policies that are well understood by the people, are easy to implement, they are not quite I would call it suffocating to the people, for instance. And I think it is, it's not really like in bad faith, because we cannot take it out and say the executive is trying to work its way around and twist the judiciary. Because you see, the judiciary is sitting as independent as well. So if a matter is brought before the, for instance, the High Court to petition against the directive of the presidency or the executive wing of government for one thing or another, probably they feel something has been infringed, for instance, as far as their rights is concerned, then it has to follow through the stream. I mean, all parties present, of course, the state is represented by the Office of the Attorney General, and then, of course, the application that is coming on behalf of the people, the petitioner, then the issues are well articulated through the whole mechanism of the judicial forum. We have the competent judges, we have well laid out decisions. We are looking at the precedents and how this has informed all the decision to the point where the final decision is given or the verdict is given by the competent court of law. I think that it should become very well respected to the point that if, for instance, the executive wing is dissatisfied at how the court has arrived at the decision, probably it might be a question of revisiting the policy implementation framework. Okay. Because I don't think it is totally like, it's like throwing out the whole idea out. It's mostly the impasse arrives at the point where the implementation rubs the wrong way, probably in a way that it did not factor in certain concerns of the people, especially when you're looking at implementing new policies that probably needs time, consultation.
That's where public participation really comes in. Yes, it
requires proper articulate forums to educate the populace, to bring them up to speed, to make them understand what is the gain or what are we trying to achieve when it's said and done. So it's not just a forum where you just arrive and say, okay, well, I think this policy, for instance, if we overhaul probably the insurance policy, or if we overhaul the tax system, if we overhaul this, if we include this, it is fine by us. It is then become, it's become a bit uncomfortable, and that is why we have the avenue of the judicial system, which of course the executive need to respect as far as separation of powers is concerned.
That respect, recently in this country, there has been this tendency by the political class to really bash the judiciary, especially those on the government side, because of one ruling or the other. For instance, the affordable housing policy. It was put on hold, and then what followed was the judiciary being accused of enjoying the benefits of having affordable mortgages while denying ordinary Kenyans the opportunity to gain something of a similar nature. But so far, we can say that the judiciary has been stood their ground. And that is where my next question comes in, and that is regarding the independence of the judiciary. In your opinion, as a person or a professional working in that, that sector, the judiciary and the legal sector in this country, what would be your opinion regarding the independence of Kenya's judiciary? Is there anything that you have seen that would suggest to you that all is well? The judiciary in Kenya is standing firm, it's independent, or are there some, events or matters that have probably caused you to question the independence of the judiciary?
Well, I don't suppose in the strict sense. I said there is the perceived, and then, because what we really feel generally is more what is perceived as having been undermined by remarks that has been made by the political class. But then we are looking at it from the perspective where the firm hand of the judiciary has stood as far as directions that have been issued by the courts have been made. And we are not expecting, because you see the presidency, the executive is well articulated, the position, the functionalities is well outlined within the Constitution of Kenya, which all requires that all of them are bound by the Constitution. So the remarks notwithstanding, we still feel the judiciary is still independent. We are looking at it from that perspective because the judiciary still has its role and it's not gagged in the strict sense. We are not looking at passing vain directions and court orders that are just issued as paperwork and theoretically aspects that we celebrate good rulings that are given by the courts. given the set of circumstances, but when it comes to implementation or having, for instance, orders of stay, again, a certain directives of the directives that have been issued by the executive, we are expecting, because you see, I would call this, for instance, we recall the promulgation of the Constitution 2010, and it became like a dawn. Some people would say this was a kind of a realization that we've come to the place where the nation is mature. Everybody is excited about the new constitution, is set out properly the functionalities, everybody is bound by the rule of law, everything is going to flow smoothly. And of course, with our current president-elect, we are looking at a very honorable man, His Excellency, the President of the Republic. We are very honored to be, you know, under such sound kind of leadership. But on weighing the question of theory and practice, we are looking at it, I would say, is purely perceived. I don't think it is yet declared to the point that judicial functions have been gagged so far. We are looking at, yes, it is a question of contest. It's a question of contesting that, yeah, you know, we have passed this direction, the judicial functions have been well outlined, matters have been presented before the courts, directions have been issued, orders have been given. We have not seen yet where it has come out clear that the directions or the court orders have been totally disregarded in that sense.
But there has been, you know, proclamations.
Yeah, proclamations
by certain leaders about the intention by the government to go against some of these rulings, some of these orders that are given by judges, and up to a point when the LSK had to protest. The members came out, walked about in the streets of Nairobi protesting the perceived attempt by the government to muzzle the judiciary. And these utterances by the president and his people that they were not going to abide by some of these rulings. I mean, as a member of LSK, would you support such actions by LSK, and would you rally behind their concerns?
Well, that's a very tricky position for me to take on this. But it doesn't mean that we are, the fact that we say directly or otherwise that we rally behind is not really the question. The question is, what do we really stand for? When we take our oath of office, we all say we shall safeguard the Constitution because it's the supreme law. And it is just a call, it's a wake-up call to both the executive and the legislature, and of course the judicial wing, which are of course the three arms, to reconsider the position, because you see, unfettered power, which has not, the power that is unchecked is dangerous, because we don't want also the overstepping of the executive on the issues of the judiciary. And also I would still say it is literally still where we are hanging in there, saying that, well, we maintain, of course, as an office, as an officer of the court, I am practicing in the High Court of Kenya. I mean, of course, we rally behind our colleagues. We believe the rule of law. We believe the constitutionalism. We believe in the separation of powers. And the question would be now implementation, because what we are looking here is really not the question of whether we are rallying behind or not. It is the question of what do you think about the executive and the judicial functions, and we are just saying they ought to operate within the confines of the Constitution. The confines of the Constitution under Article 2, Sub-Article 1 gives it very clear. And of course we have the judicial wing, which anybody is at liberty. All the Kenyans, and I mean, if they feel at any time anything is not sitting right within the policy framework, implementation phase, and the safeguard, because the Constitution is a sovereign law in any nation. So we are looking, if anybody is aggrieved by any decision, then they should be at liberty to approach the courts and have it articulated very well. So then we have the balances, because without checks and balances, then we are looking at it's a crisis that will be looming, because in the whole process of implementation, we don't want overlaps, because we already have some matters that have already been filed before the judicial, the competent courts, and if at all they are supposed to be gagged and they are not ventilated in the right way, still, even the executive itself might come to find it very difficult to implement, because already some of them already are overlaps against the already existing statutes that we would like to know which one takes precedence in that case, or how then do we weigh out the issues.
And as we wind up this segment, because I'm told you're supposed to go for a short break, just one quick one. Are we, I mean, you have used the term perceived a lot, which means there could be more to this issue than we can see, and probably it's just a matter of perception, really. But are we in danger of being misled by politicians? Because remember, in 2022, when the Supreme Court was deciding on the presidential election, the Kenya Kwanza side, the decision of the court favored them. And they really praised the Kenyan judiciary at that time for being independent, not bowing to pressure from international community, from the opposition, from everybody who was against the Kenya Kwanza team. Fast forward a few months later, and the implementation of the Kenya Kwanza plan took off. These obstacles here and there, and the tune has changed. So is it really the judiciary that is the problem, or is the politicians who want to have their cake and they want to eat it at the same time?
Well, I really don't think there is any diversionary tactic by the politicians in any sense, because we are not losing sight. The Constitution is really outlines their powers. The politicking of the day by no means overrides the rule of law or the constitutional safeguards and the provisions that are outlined. The fact that, of course, anybody would feel good if any decision were made in your favor at the moment, considering the tension that was already building up, leading to the Supreme Court decision and everything. Well, everybody, when they get a win, of course, you'll always laud the system at the moment, but it doesn't mean that it by no means is saying that the judiciary was performing a better, was observing or probably doing more justice at the time as opposed to what is doing currently, because we are looking at partial arbiter, that if a matter is brought before the judicial office and favorable rulings, we call them rulings because we won't call them favorable against either party. If it goes against the petitioner, if it goes against the respondents, I don't think it is a question that is a partial arbiter. It weighs out the issues and looks at against the backdrop of the Constitution, against the backdrop of the law that is seeking to be challenged or probably to be looked at. So we are not looking at it like it was celebrated then, but now we are castigating it. We are just discussing this in light of should the executive step down, or are we looking at a place where there will be acrimony as far as implementing policies that looking at the judiciary as fighting the executive in the real sense, so that the executive is unable to perform its function of service delivery to the people. Because of the judiciary. So then it ends up violating the very essence of the office, because you see, when it comes to power, every president would like to have policies that they will leave legacies, having developed, having met the agendas, having delivered to the people. It's a question of checks and balances, which takes us back to what I already said. I don't think it is already a stalemate in the strict sense. I think it is a question of the executive revisiting just how to implement these policies for the interest and the benefit of the people, while the judiciary is allowed to carry out its mandate according to the Constitution, which lays out that if anybody is aggrieved by any decision, or they feel that it is actually, in a way, infringing certain provisions, that it's not good for the general people, general populace, it can still go back to the courts. But it doesn't mean that the courts can literally just have to throw it out in. It could even ask that certain positions be reconsidered before it is totally either done away with or in a way that is implemented in a way that it serves the very interest and it serves the purpose, which of course now is what we really need to draw the line on.
Okay.
Yeah.
Thank you very much, Wakili, for your time and your insights regarding this issue about the judiciary and the executive and the perceived stalemate. And we hope to talk to you again soon regarding this and other matters that touch on the law and the judiciary. And with that, we are going to take a short break and then we come back. And when we come back, we'll be in studio with Felix. So I hope you'll be watching on the other side.
Yeah.
Yeah, gongoi missing chitab college inano go wakili inendet ko giliot Dr. Grace Pharez nekamuch kokonech kasarta nyin kong'ololwech akobo koimutiet nekokomuch kobit en emetab Kenya noton neterchinet en kwenutab kapkirwok ak kebeberta nebo executive kosubkei ak kasuldaetab tuguk cheterter chemoche kosuldaen serikali kobaten chekomuch koityi konogutiet en kapkirwok chebo emetab Kenya. Kibendi kimunyi kasarta nenwach en tetutiet nebo Ikweny Emet kiweksei nematyan ako yekiwege ketindoi tondet age kora inendet ko giliot kora age nekibendi kenyoru ng'alalenyin yekiwege en kasarta nenwach.